Sergeant at Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the May 28, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the May 28, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will please call the case before the Senate acting and sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, may we ask the parties and or their respective counsel to enter their appearances.
Good afternoon, Mr. Senate President, and ladies and gentlemen of the Senate. On the part of the House of Representatives Prosecution Panel, same appearance, we are ready, Your Honor.
Noted. The defense.
For the defense, Your Honor, the same appearance. We are ready for the scheduled promulgation of the decision in this case, Your Honor.
The Majority Floor Leader.
Mr. President, the Senate has met as an impeachment court for 44 trial days, starting January 16, 2012, to consider the articles of impeachment against Chief Justice Renato C. Corona. The court convenes today to conclude this trial by voting on the articles of impeachment. Mr. President, pursuant to Article 11, Section 3, Paragraphs 6 and 7 of the Constitution, and Rule 21 of the Rules of Procedure on Impeachment Trials, we are ready to vote on the articles.
Before we proceed, the Chair would like to remind the members of the Court, the parties to this case, and the public that on March 12, 2012, this Court ruled that no evidence from both the prosecution and the defense will be received and no verdict will be rendered on Articles 1, Roman numeral 1, Roman numeral 4, Roman numeral 5, Roman numeral 6, and Roman numeral 8. In accordance with that earlier ruling, the votes will only be taken on Articles Roman numeral 2, Roman numeral 3, and Roman numeral 7. The Clerk of Court will now read Article 2.
Article 2. Respondent committed culpable violation of the Constitution and / or betrayed the public trust when he failed to disclose to the public his statement of assets, liabilities, and net worth as required under Section 17, Article 11 of the 1987 Constitution.
The question is on the second article of impeachment. Senators, judges in this impeachment court, is the respondent Renato C. Corona Chief Justice of the Supreme Court guilty or not guilty. The clerk of court will now call the roll, and each senator shall have time. We will not limit the time. This is a historical event, and each one of us must vote according to his conscience and explain the reason for his vote. So therefore, each senator shall have as much time to explain his or her vote in this case. Proceed.
The Honorable Senator Judge Angara.
Thank you very much, Mr. President. Mr. President, esteemed colleagues, distinguished brothers in the profession from the prosecution and defense, ladies and gentlemen. Kung nalaman ko lang, dinala ko na yung libro ko, Mr. President. Sa nakalipas na 5 buwan, ang atensyon ng sambayanan ay nakatuon sa impeachment trial ni Chief Justice Corona. Mula sa pagiging pribadong abogado, siya ay nanungkulan sa ilalim ng 2 Pangulo at nahirang bilang pinakamataas na mahistrado, isang natatanging tagumpay para sa isang abogado at ang pinakamataas na posisyon sa isa sa 3 magkakapantay na sangay ng pamahalaan. Ngunit napapaloob po dito sa isa pang istorya. Ang kwento ng isang pamilya na pinagwatak-watak ng mapait na away tungkol sa pag-aari at pera. Tumagal ng 30 taon ang away, nauwi sa demandahan at humantong pa dito sa paglilitis natin. Pera, kapangyarihan, away, pamilya, ito po ang ugat ng istoryang ito. Hindi ang lahat ng ito ay matutugunan natin sa paglilitis na ito. Subalit, hangad ko po, na sana dito rin ay magkaroon ng hantunan o closure ang away pamilya. The question, Mr. President, is quite simply, is the Chief Justice alleged failure to disclose a true and complete statement of assets as mandated by the Constitution, and whether this constitutes culpable violation of the Constitution and or betrayal of public trust. The Constitution and our statutes oblige every public official to make and submit, and I quote, a complete disclosure of his assets, liabilities, and net worth, or SAL-N, in order to suppress any questionable accumulation of wealth. This obligatory constitutional rule seeks to eradicate corruption, promote transparency in government, and maintain a standard of honesty in public service. The prosecution and the defense, Mr. President, combined as one in producing proof that the Chief Justice has bank accounts that he did not declare in his SAL-N, and removing any iota of doubt about this vital fact was the Chief Justice himself coming here to testify openly and openly admit that in fact he did have 4 US dollar accounts totaling 2,400,000 and 3 peso accounts of 80,700,000 pesos. I may grant the Chief Justice plea of honest mistake of judgment, but given his broad experience in public law and practice in investment advisory services, this willful and deliberate omission, together with the magnitude of the amounts involved, amounts to culpable violation. Yesterday you were asking what's the root meaning of culpable, Mr. President. I just looked up this morning what is the dictionary meaning of culpable. It means simply a failure meriting condemnation. The Chief Justice justified his willful failure to disclose his US dollar accounts on the so-called absolute confidentiality provision of the Foreign Currency Deposit Act. However, it seems clear to me, Mr. President, that the mantle of protection is extended to foreign depositors, to foreign savers, in the spirit of promoting foreign investments. The law was never intended to be a convenient excuse for Filipino, especially for Filipino public servants, to conceal their assets. When the accounts were disclosed by no less than the Chief Justice, this left this court no restraint, no constraint, no prohibition against admitting the evidence and weighing it on the scale of justice. The defense argues that the Ombudsman illegally obtained documents on Chief Justice bank transactions where there was no pending case involving the subject bank accounts, or any court order authorizing the production of such records. Mr. President, this argument overlooks one important fact. It fails to consider that the documents produced by the AMLAC, or rather produced by the Ombudsman, were official records of the AMLAC, which it receives from covered institutions pursuant to law. The Ombudsman has the power and the authority to obtain these records from the AMLAC pursuant to the Constitution and the Chief Justice's own written waiver on his sole end. On the whole, Mr. President, the defense main objection doesn't sound acceptable. It rings hollow to me, since the Chief Justice himself admitted to the existence of the accounts, and more than that, the amounts they held, not to mention the fact that information on these were provided by witnesses presented by the defense panel themselves. The Supreme Court no less has said, no position exacts a greater demand on moral righteousness and uprightness of an individual than a seat in the judiciary. As the head of the judiciary, a standard far higher is placed on Chief Justice Renato Corona. This impeachment breaks new ground. This Senate, sitting as judges, adopts its own rules and makes its own decision within the bounds of the rule of law. It can initiate new doctrines. It can pass new precedents. Its pronouncement is the final word. It seems unnecessary for me to dwell further, Mr. President, on the 80.7 million account of the Chief Justice, which he said is a commingled fund, commingled with the funds of his children and the Basa Guidote family. But this fund could very well provide the seed of reconciliation for the two feuding branches of the family. For this reason, Mr. President, I find the respondent guilty.
The Secretary.
Honorable Senator Judge Arroyo.
I will not discuss what both the prosecution and the defense had already argued in the closing arguments. Mr. President, esteemed colleagues, impeachment is a political process, not a political assassination. An impeachment aspires to be a judicial proceeding that makes it imperative that it stick to judicial rules. And impeachments